Hello, everybody. Welcome to the United States legal system introduction video. This video is part of the English legal writing course online. What will we talk about in this video? So we're basically going to talk about the key features of the U.S. legal system. This is federalism, separation of powers, sources of law, and then the weight and hierarchy of authority. And this is all as background to inform us for our legal research. So federalism. What is federalism? So you've heard that the United States of America employs a federal system of government. This means different things to different people. But basically, it means the entire state, that is the United States of America as a state, is divided between the federal government and the local or state government. In this situation, external relations are controlled by the federal government. Basically, the federal government has its own powers, and the state governments have their own powers. So basically, the takeaway is there are two separate governments in the United States in terms of lawmaking power, in terms of the courts. And we need to understand that for our research, we just need to be cognizant of the fact that there is a federal system covering the United States and a particular state system that is controlling a particular area of the United States. So I briefly kind of mentioned the federal powers. A couple of examples of the enumerated federal powers. And of course, we can find this in the Constitution of the United States. But basically, the enumerated powers of the federal power would be taxation, regulating what's called interstate commerce with foreign nations, and what's referred to as Indian tribes in our Constitution, immigration and naturalization, bankruptcy, creating money and regulating the value. The mail is a federal power, copyright, patents, intellectual property. We have the creation of federal courts, and then this kind of catch-all in Article 1 that relates to making laws that we need to carry out that are necessary and proper for carrying into the execution the foregoing powers. So these are the enumerated powers of the federal government, kind of a summary of the enumerated powers. So how does this kind of impact our legal research? So you'll just need to realize that you could possibly be looking into two completely different sets of laws, right? You have the federal law or the state law, which will apply in a certain territory. Sometimes what law applies might be obvious. Sometimes it won't be. So an easy one is copyright. Copyright is a federal power, right? If you ask any lawyer, they would say this is a federal power. But, and I referred to this before, is the interstate commerce power is kind of broader language that's been interpreted and expanded over time. So you might find that it's not so easy to understand what is interstate commerce and therefore regulated by the federal government as opposed to something that might be regulated by a state government. So we have a federal law. There's one federal government, and there's each of the 50 states that produces its own set of laws, even argue including DC. We also have what's called domestic dependent nations. These are American Indian tribes, which have a form of sovereignty. So not only do we have federal, 50 states, territories, and the sovereignty granted to American Indian tribes. So we have to think about these subjects when we're conducting our legal research. What might further complicate it is that a jurisdiction's court system might not apply its own set of laws. So a court might do what's called a choice of law analysis, which has a number of factors and guiding principles about what law or what sets of laws that the court should apply for a specific situation, which is an entirely separate course than this. But just be aware that there's this choice of law in asking ourselves as a basic question, what law applies in a particular situation. And this is true in the United States, but it's also true and in international commerce, which particular jurisdiction's law applies. So now moving to this idea of separation of powers and sources of law. So the people who wrote our Constitution, they divided the powers of the central government into three distinct branches. And this is in Article 1, 2, and 3. And they did this, they broke it into legislative, executive, and judicial. And each branch has its own specific authority that it has. And the idea is each branch is checking the other branches. So no one branch is becoming more powerful than the other branch. States have most states have a similar situation. So you'll see an executive and judicial and legislative branch in each state. And each branch is contributing to the body of law. So each branch will have its source of law. So the legislative branch passes statutes. The judicial branch will have cases, opinions, judicial opinions. And the executive branch has regulations. But at the top of all of this is the Constitution, which is the highest source of law. So for a legal rule in the United States to be valid, it will have needed to have been created by a process described by the Constitution, whether it's the federal Constitution or state constitution. So for the United States, the U.S. Constitution is the rule of recognition by the federal government. And similarly, the state constitution serve as the rules of recognition for the whatever state you're referring to. So in terms of statutes, which are governed by the legislation, the legislative branch creates laws in the forms of statute. And we'll talk about how it's created in another video, but in general, a legislator will introduce a bill into whatever legislative house she belongs to. If it receives enough votes, it will go to the executive for signature or veto. But basically, after the executive approves, it becomes a law. So in the United States, we have the House of Representatives and the Senate. When a bill passes both houses, it gets the designation called a public law. And we'll talk about this in another video in more specific. The GPO, the government publishing office, will publish the public laws of the United States into a set called the Statutes at Large. Then after that, it will get organized into the United States Code. And the United States Code, or the USC, is basically what lawyers use to research the law. They're organized by topic, so you can easily browse topics. And the different services will sometimes provide annotations to the code. For states, we have a similar process, almost identical to the federal process. So judicial opinions. So that would be statutes, judicial opinions. Statutes are often, they are usually drafted very broadly to cover a lot of different factual situations. So in any specific situation, it might be difficult to determine how to interpret the law given a set of circumstances. And this is where judicial opinions come into play. So the courts will issue opinions on a different issue relating to a statute, for example. And these judicial interpretations will take the form of a judicial opinion, which create judge-made law, which is commonly referred to as the common law. This creates consistency across the different courts. Consistency is a good thing. We call this judicial precedent. Society benefits if courts are consistently interpreting a statute in the same way. So then administrative regulations. So administrative regulations are issued by the executive branch. And these are laws that really drill down into a more detailed level of specificity. We often talk about regulations as implementing the statutes. So that's discussing we have the Constitution, and we have the legislative branch issuing statutes, the executive branch issuing regulations, and the judicial branch issuing judicial opinions, interpreting the statutes. So in terms of legal authority, going to our legal research point of view, legal authority can be basically divided into two broad categories. We have primary authority and secondary authority. We often call this the type of authority. Primary authority is the authority that's issued directly from a lawmaking body. So sources of law, we talked about 4 sources being 1, the Constitution, the statutes issued by the legislature, the judicial opinions by the judiciary, and the regulations issued by the executive. These are primary sources of law. Secondary sources are authorities that explain the law, but don't establish the law. So talk about treatises, annotations by private companies. We have law review articles. We talk about secondary sources in another video in depth, but those are kind of the basic types of secondary sources. Then we have this idea of mandatory versus persuasive authority. So mandatory being binding authority, and this is collectively referred to as the weight of the authority. So now we have type, and now we have weight of authority. So mandatory authority is authority that courts must apply. And then persuasive authority refers to authority that has some weight, right? But is not binding to the court. So what's mandatory and what's persuasive then? What's binding? How do we determine the weight of the authority? Sometimes it's straightforward, sometimes it's not. So for example, our Constitution acts as mandatory authority. If a statute from a jurisdiction relates to a set of facts, then you have to apply that statute. Same thing for regulations. So Constitution, statutes, regulations are they're either usually mandatory or irrelevant. They're not persuasive. So secondary authority, on the other hand, is usually never mandatory, but will always be persuasive authority. This would be kind of an easy kind of summary of mandatory and persuasive authority. Judicial opinions, on the other hand, the weight of authority of judicial opinions depends on some more detailed factors. A lawyer needs to consider the choice of law in a certain situations. The precedent must apply the same jurisdiction's laws to the controversy. We need to consider the venue where this controversy will be heard if it went to trial. So for example, we have 11 circuits, the DC circuit and the federal circuit. We have different states as well with state courts. So in determining the hierarchy of authority is a skill that is developed over time. And we'll talk about this in more detail in other videos. But for purposes of this video, just realize there's mandatory and persuasive authority. So I think that's all I'd like to talk about in this video. Thanks everybody, and take care.